Afternoon, Chief Justice.
How are
Good
you,
afternoon,
sir?
Commissioners. I'm fine. I'm very well, thank you, Chief Justice.
Thank you. I'm very well, thank you. For how many years were you junior counsel?
For 20 years, Chief Justice.
And senior?
For 8 years.
For how many months or weeks have you acted as a judge?
At present, I've done 62 weeks, and I have another 10 weeks ahead of me. This is the fourth term.
In the 62 weeks, how many judgments have you written? More or less.
More or less. Chief Justice, I don't have these spreadsheets in front of me, but I think I've handed down in the region of 150 or 160 judgments. And out of that, the majority have been extempore, and I've probably written about 15 or 16.
Yes. And what is the longest it took you to deliver a judgment that was reserved?
Just short of 3 months, Chief Justice.
Just short of 3 months.
Yes.
Thank you. JP?
Brad, good afternoon.
Good afternoon, Judge President.
It's been a long day.
Yes, it has. And I'm sure it's been longer for you.
You've acted for 62 weeks, and you've done, and I must disclose this to the Commission, you are from KZN,
That is
but
correct.
you've been acting at no cost to the division from an accommodation point of view.
Yes, that's correct. I've picked up my own accommodation and travel costs.
Right. Now, I just want to pick on the judgments that you say you wrote. You say the majority have been extempore. Right.
Yes.
I just want to know what the yardstick was for you to deliver the majority of your judgments extempore. And the reason I ask is because almost all the candidates who've come here have written the majority of their judgments. They were not extempore. So I want to know what was the criteria that you used to deliver your judgments extempore? Because usually it's in the agent court that you'd expect judges to deliver extempore judgments.
Yes, yes. And certainly I did there, Judge President. But yes, the yardstick being that when I first started acting, I was advised that obviously in order to get those judgments out on time, that in many cases it would be advisable to give these judgments extempore rather than deliver written ones, which would take more time and would then delay the process. So bearing in mind that a judgment is a debt which the court owes to the litigants, I've decided to embark on that route. And that really is an aim to have those judgments out as soon as possible, and likewise to have them done before, if possible, before at the end of each acting stint. So in other words, that I left with a clear slate and obviously a clear conscience.
Yeah.
There were one or two, in having said that, Judge President, obviously the extempore judgments, some were delivered within a week, others would take more consideration and would be delivered in 6 weeks to 8 weeks, and even others of some, well, where it was within written, would then take up to a period of 3 months.
Yes. You did some 8 weeks in criminal trials.
Yes.
It was a new experience for you, in a sense.
Well, yes. I had, prior to going to the bar, I prosecuted in the Durban Regional and Magistrate District Courts
Yes.
for approximately 18 months, and then went straight to the bar. For the first probably 5 years of my practice, obviously I did pro deo work in the High Court, and I was also briefed in the High Court on criminal matters and also in the district and regional courts.
Yes.
So I did have some experience. Then my practice then turned to a civil route. But coming back to the 8 weeks that I've had now, I've managed to settle back into crime, actually, and feel quite comfortable in that sphere.
Yeah. You're a silk. You've given me a lot of acting time for a silk. Is there a reason for that? When I say for a silk, the silks are stingy.
Yes.
with their time to act?
Well, Judge President, that how it arose, in fact, was when I attended the conference held by the Johannesburg Bar. That's the Transformation Committee of the Johannesburg Bar at Lily Leaf Farm in 2015. And when you, Judge President, addressed that conference, you, if I can use the word, bemoaned the fact that you weren't getting enough time, certainly at that stage, and I know there has been possibly an improvement in that regard from Silks at the Johannesburg Bar and Pretoria bars to act, particularly for long periods of time. Having made the decision that I wanted to give back to the profession and to the administration of justice, I then obviously offered my services to you on that basis. And having done that, I think that was an honour that I've been able to, something that I wanted to follow through with. And also I owe a debt of gratitude to both yourself and also to the colleagues in Gauteng and generally and the collegiality and for making me feel so welcome there.
Thank you, CJ. No further questions.
Thank you, JP. MEC?
No questions.
Thank you. Commissioner Mpofu?
Thank you. Good afternoon, Judge.
Good afternoon, Commissioner.
Yes. Just one question. There's a recent judgment which is in the very latest law report, the October law report, Atlantis Holdings. Ring a bell?
I'm afraid it doesn't.
It doesn't.
No.
Okay. Well, that's a judgment in relation to the battle between Pacta Sunt Servanda and Ubuntu, where you sat as part of a full bench. If I'm not mistaken, let me just double check. Because if it's that recent, it should ring a bell to you.
No, I don't think so.
Okay, have you ever, let me do a shortcut.
Yes.
Have you ever sat in a full bench decision, appeal with Valley, Judge Valley?
No,
No,
I haven't.
okay,
I haven't
then
said-
it's a different judge, yeah.
Yes.
Okay, thank you. Well, I might as well ask you then, since you're here, what your if any, if you've come across and what your view is on the debate between Pacta Sunt Servanda and the infusion of Ubuntu into our law of contract. And Vali in this judgment says that, and I agree with him, that the SCA has taken the more conservative approach on this matter, and the Constitutional Court is leaning more towards the Ubuntu kind of approach. And it looks like it's unresolved. Have you come across this in your either in practice or in your judicial career acting? If so, or whether you have or not, if you are aware of the debate, where do you fall?
Yes, Commissioner. Again, I must apologise, and I'm not aware of the debate at all. The only way in which I could answer the question, or perhaps shed some light in that respect, is that obviously with Ubuntu being the virtues of compassion and humility and sharing, that is obviously something which we should look to in light of and in terms of customary law to introduce into our law insofar as we can in respect of the common law and also in terms of the Constitution. Having said that, I was party to a full bench criminal appeal where counsel should argue, where I sat with Victor J, and counsel argued the principle of Ubuntu on the question of sentence. Victor J gave the judgment, but that was an interesting argument, and it's pleasing to see that is in fact being a factor or being developed into our law.
Thank you. Yes, that must have been a creative way of introducing Ubuntu into sentencing. Thank you. Okay. Thank you, CJ. Thank you, President and CJ.
Thank you so much, my brother. Commissioner Norman?
Thank you, Chief Justice. Good afternoon, Council.
Good afternoon, Commissioner.
I've been wondering what happened to you. I now know that you've been hiding here in Johannesburg.
Yes.
Thank you. Just on the judgment that you wrote, It's the matter of, sorry, I have a tendency of just going to the last page. The Ashley Jijo matter and tires 2000.
Yes.
There was a tender made there by the defendant. I just want to know whether it was not perhaps appropriate to consider the fact that a tender had been made, though it was for a less amount than the one that you ultimately ordered, whether you should not have taken that factor into consideration when you were awarding costs.
Yes. Possibly, Commissioner, I see the point, and,
Yes,
and
yes.
obviously a common law tender should always be taken into account.
Yes.
Perhaps I framed the judgment perhaps not as clearly as I intended to, but applying even the principles there too, and also the principles in respect of for example, a Rule 34 offer. I think I was satisfied on the facts before me
Yes.
that the tender having been so low, it was insufficient to warrant any acceptance, and therefore didn't have any effect
On
on
the
the
cost.
issue of costs.
Thank you. Thank you,
Thank
Chief
you.
Justice. Thank you.
Thank you so much, SC. Kane, SC.
Thank you, CJ. Good afternoon, sir. One quick question from my side, just
Yes,
to
ma'am.
clarify an issue that the GCB rose, and I'm sure you've seen it.
Yes.
It appears to me that you may be too young to retire from practice, and yet you've resigned from the KwaZulu-Natal bar and seem now to be acting on a relatively permanent basis. What are your intentions, or what is the cause of the resignation from the KwaZulu-Natal bar?
Yes. It really, Commissioner, and again, I bemoan the fact that KwaZulu-Natal, as opposed to this division, or the Gauteng division, the amount of work available in any given space, there's a vast disparity between the two. And in fact, that has in fact given rise to a flux of council, in fact, resigning from what was the former bar, and the maintaining of chambers, etc., and incurring those expenses. That said, that wasn't perhaps the main reason. Once the opportunities began to arise to act, and having made a conscious decision that even at this stage, and I don't think I'm that young anymore. It's very kind of you to be 57. That the time had perhaps come to seek another avenue, and that's why the event. There was also the establishment of a company in 2016, which also to one extent or another made that decision for me. Yes.
Thank you, CJ.
Thank you, SC. Commissioner Fourie.
Thank you. Just a very short question. Good afternoon. I'm just curious, you practiced in KZN and you acted there once for about 3 weeks in 2012.
Yes, 4 weeks.
Is there any particular reason that you are aware of why you haven't been invited back to act in the KZN High Court?
Yes, Commissioner, that's a good question. I have no answer for that, other than to say that I have always made myself available, and I have also tended to, once having had the experience of acting in Gauteng, to share that experience with the KwaZulu-Natal division, but none of those advances or offers were taken up.
Thank you. Thank you, Chief Justice.
Thank you so much. Commissioner Mpofu?
Yes, thank you, CJ. No, I just wanted to explain that the quorum that in that matter, it was Judge Windel, not Wanless. So it
Thank
wasn't
you.
your fault. Yeah, it's just a W problem. Thank you.
Thank you.
Your excuse, sir. Thank you so much.
Thank you very much. Thank you.